Good afternoon, everyone. I'd like to welcome you to the Bellingham City Council afternoon committee meetings. Earlier this morning, the Planning Committee met. Our first committee of the afternoon is the Justice Committee, and April Barker is the chair of that one.
Okay, well, we just have one item, and I'm joined here with Councilmember Vargas and Borneman. Alternatives to incarceration, and just as a precursor, we've been really getting some different aspects of the judicial system throughout these committees and education. So if anybody's interested to learn what we've learned up till now, you can go to the City Council's website and click on Hot Topics and Justice System, and you can see them all in order there. I'd like to acknowledge Darlene Peterson, our Municipal Court Administrator, and Ryan Anderson, Lead Prosecutor, but we also have Chief Cook in the house. Hey, Chief Cook. Thank you for coming. And with that, we'll be talking about alternatives to incarceration, and I'll pass it over to you, Darlene.
Can you hear me okay? Okay. Thank you for having us here again this afternoon. What I'm going to do is do a little bit different sketch than we've been doing in the past. I'm going to go over some of our jail reduction programs, and I'm going to give you just a little history just because of the VERA report that just came out with the county. I thought it would help give you a perspective. So the first thing I'm going to say is in jail reducing programs, there are two categories. There are pre-conviction, which is before anyone's ever been sentenced, and then there is post-conviction. I'm going to skip the pre-conviction because that's really the prosecutor's area with most of those. That's before a person has any adjudication. And those kind of programs are really what the true meaning of diversion is. Because the true meaning of diversion is diverting someone out of the criminal justice system. And so I will leave that for Ryan. The other is post-conviction. Post-conviction is after somebody has already gotten into the system, has a sentence. What can we do to reduce jail, reduce incarceration? In Bellingham, post-conviction, some of the alternatives that our judicial branch has, and the judicial branch is the one that does set sentencing. One, we utilize community service. So if somebody we use nonprofit organizations, they can do part of their sentence and part of their fines on community service. Sometimes they can do all of it. Second, a lot of times in lieu of sending somebody to jail, the court will allow somebody to go to inpatient treatment and get credit for the time that if they successfully complete inpatient treatment. For instance, if it's a 21-day program, then the court, if they've completed it successfully, will give them 21 days credit towards their jail sentence. And so that's another alternative that the court has. A third is probation. And with probation, rather than punitive, probation is really there to modify behavior, to alter behavior. And that's the goal of probation. And in probation, we have chemical dependency programs, we have mental health probation officers who just deal with mentally ill people, and that caseload is about 200 that they can absorb, and that's through both the county and the city. I beg your pardon? Yes. And so the mental health court is much smaller, but their mental health program in probation is much larger. They also have domestic violence programs. They have anger management, and they have a lot of ways to monitor behavior. It's all supervised by the court, but the programs that they have available are more to help correct behavior. We do have jail alternatives through FDS, our Friendship Diversion, and there are some programs still available through the county that we can use. We are hoping one day to have our own work release program and some of the other programs that we could use to rehabilitate rather than just use incarceration. With our electric home monitoring, I will just briefly mention that we have had approximately 450 people to date use electric home monitoring. And the last thing I mentioned briefly before was domestic violence court. That is a specialized court where victims have a chance to let the court know how they've been affected, and we can work with the defendant to have them do programs to address the issues so that potentially that family or that relationship can be put back together. And so those are some of the options that the court has. What I'd like you to do is in your packet, if you would turn to page 38, you'll see what we call our screening tool for electric home monitoring. And the reason I'd really like to concentrate a couple minutes on this is that you are hearing from the Vera Institute something about pre-trial tools. We're hearing about validation, making sure those tools are validated. And I wanted to make one careful distinction for you. The tool that we use for electric home monitoring is not a pre-trial tool. It is a screening. It functions very much like a pre-trial tool, but that's not specifically what this was created for. Anyone who is put on SCRAM, let's say, at this point, which is generally pre-trial, alcohol monitoring only, that is something that the court just orders. You don't have to be eligible or screened for that. But for home monitoring, which is after you've been sentenced, that is something that we do a screening for. If they are in custody, they are screened by probation officers before their arraignment. If they're out of custody, they are screened at their sentencing before they leave court so they know if they are eligible. And there's an order entered. You have a copy of that in your packet. But what I wanted to do briefly is show you where we came up with this tool. And I've had some questions both from the county and from city members. How does this compare? The screening tool, which is page 38, you'll notice has 3 parts. It has a disqualification for certain offenses on the top. Number 2 is an NCIC check. And number 3 is a risk assessment. The number 1 piece of this, the disqualification, comes from RCWs that we have that were...
Excuse me. Could you explain to everyone what RCW means?
Oh, that is the Revised Code of Washington. Thank you.
State law, basically.
State law, yes. And I won't go through reciting them all to you because there's quite a few. But these were really developed for Superior Court. So most of these limitations by statute or by Revised Code of Washington that's set up by the state apply to felony cases. Most of our defendants are not here on felony cases, but they may have felony cases in their background. So that is why that portion is there. The second part is called an NCIC check. And to boil that down, what it really means is a nationwide check to find out what background somebody has. If they've had a domestic violence incident in Rhode Island, that would show up. If they've had a domestic violence incident in Alaska, that would show up. And that gives the court another idea about that person's background and history, and it's just one of the factors. The third factor, which is probably going to coincide most closely to what Vera Institute is talking about, is the risk assessment. And you will notice 9 questions. This group of 9 questions was taken from 4 validated tools. They were the Virginia, which was 9 questions, the Kentucky, which was 12, Colorado, which was 12, and the Ohio one, which you may have heard talked about in the jail task force, was 7 questions. We took 6 of the questions in our sample were common to all 4. So we took 6 questions that all 4 had and put those into that. And then judicially, it was reviewed, and there were a couple of questions added at the judge's request. And that is how we came up with that part of the risk assessment. So while our 9 questions weren't validated in themselves for our community, they were taken from 4 validated tools. So I wanted to explain that to you so you knew the difference if you're asked, what is City of Bellingham doing? What are they using? That's how we came up with our tool. So the other thing I was going to show you, if you'll look in your packet, and I believe it's the next page. I'm losing my place here. You will see the home detention order.
I think Pinky has a question right before you go to the home
Darlene,
detention.
before you go to the next page, can I ask a quick question?
Sure.
So there's 2 things on page 38 that I didn't know what they were.
Okay.
What is unlawful imprisonment? What does that mean?
I think I'm going to let Ryan explain that since he's the prosecutor.
Well, it's a felony charge, very specific facts, but basically you just don't allow someone to leave. You unlawfully imprison them. You keep someone in their house, you prevent them from leaving, you barricade the door and tell them they can't leave.
Okay, thank you.
And did you have another one?
And then the other one was question number 4, have the history or 2 more FTAs
Okay, those are failing to appear.
failing to appear? Okay.
So is this person usually at court when they have court, or do they not respond? Okay. So if you turn to the tool, which is page 39 in your packet, you'll see in the middle of the page there's a paragraph. And it tells them exactly what they may leave their home for while they're on. And remember, this is in lieu of jail, so it is confinement. But in this situation, they're allowed to leave for school, work, treatment, counseling, probation, parole, medical, dental appointments, scheduled court hearings, scheduled attorney appointments, child care if they need to drop their children off at child care before they go to their work. And then there's a place for others, so that if something else comes up, they can come before the court, or they can have their attorney address the court so that they can have that exception while they're on the bracelet. One of the things that I will note is that I've been made aware of somebody with the county who was on a bracelet and had some issues. To my knowledge, the county has not gone through and come up with a contract with Friendship Diversion Services. They don't have any oversight over it. And so I just want you to point that out to you, that that's something that we do have with the city. Peter Fotto went through, Ryan Anderson, there was a group of us, we came up with a contract. We have strict boundaries about what is allowed on FDS and what is not. And so, and we oversee that very closely. And the last point that I'm going to make for you is something that I think is the most wonderful part of this, besides the cost savings, which I won't repeat all those numbers. It's in your packing. Although, maybe I will repeat
Yeah,
that.
I think it's
I think you
important.
should.
This is
Okay.
an opportunity for our constituents as well as ourselves
Okay.
to understand that not only are these helping our citizens to stay at work and take care of their families, but it's also, there's an economic benefit to it as well.
There is, although I want you to know that's not our priority in doing it.
Nor ours, however,
Okay.
we have a budget.
But in 2012, we had 3,090 days served on FDS, Friendship Diversion Services, electric home monitoring. We paid $14,757 approximately to supplement indigent people, people who did not have the funds to be able to do this on their own. Had those people served those same 3,090 days in Whatcom County Jail, it would have been over $303,000. In 2017, just through August, we have had defendants serve 5,477 days on bracelets rather than in the jail. We have supplemented those people who needed help at about $51,000. Had they served it at Whatcom County Jail, which is now up to $108 a day, it would have been over $592,000. In addition to the financial savings, what has amazed me is the amount of follow-through success that we are having. In the 418 people that have served those 8,000 plus days now on bracelets, we have 10 people at the end of August, 18 months of doing that program, we had 10 people out on warrants for not complying. That is over a 97% success rate. Are there going to be issues? Is it perfect? No. But we have found that this is just a fabulous tool in so many ways. But to have that kind of success rate, I think, is pretty unheard of in most criminal justice programs. And that's one of the things that really excites me. And so if you want to have questions after Ryan's presentation, or did you want to do that first? I'm not sure.
Do either of you have any questions? No, I think once we hear Ryan's, then we might be able to go
Sure.
back to more non-committee member. I'm just kidding. Michael, do you have a question?
I just want to raise an issue, and maybe you can give me some insight. So, as you say, for these services, if you're qualified as indigent, then the city will pick up the tab, and so it can continue to that person can have the benefit. I'm wondering if there isn't a level above indigent that still is in financial need.
Yes.
You know, is there a sliding scale of any
Yes,
sort? Okay.
there is. And what we use is 2 times the poverty rate. And so, or excuse me, 1.5 times the poverty rate. It's higher than what the poverty rate is, but it's on a sliding scale. And some people pay $1 a day. Some people pay $1 a week. Some people don't pay anything. It just depends on where you are on that scale.
Peter?
Yeah, just to follow up on that, that's an example of where having established a contract with a specific provider and having a relationship with that provider, we can fine-tune various aspects of the program. And that actually was an issue that came up where Friendship Diversion was saying, you know, even though we thought we had a pretty good sliding scale, they said there were a few people they were seeing, and in fact, they were even, I think, considering sort of subsidizing it themselves. And we said we should formalize this, and we actually increased that threshold in response to what they were seeing as far as people who may not be able to afford it at the previous rate. So in the last round of contract, we actually increased. We lowered the threshold. I'm not sure exactly how to say this, but I think you catch my drift. And so that's something you can do when you have not only a contract, but a relationship. Because keep in mind, there are providers of electronic home monitoring all around. Security companies will do it, but those are just, you know, they may be fine, but they're not someone you have a specific contractual relationship with.
Excellent. Thank you. You ready, Ryan?
Okay, thank you, Ryan Anderson from the City Attorney's Office. I apologize, I'm battling a cold, so my voice is a little hoarse. So maybe I won't talk as fast this time.
You'll have to breathe through your mouth.
Hey, I used to be a
just kidding.
debater, so I could talk even faster if you really wanted me to. But I do apologize if I'm hard to hear. So I think there's a lot of information in the materials that have been provided, and I can answer some specific questions about that. So I won't drag on too much, but I'm going to give you some concrete examples and talk a little bit about what we do in utilizing some of these tools. I think it's important to kind of get that when you're resolving a case or you're looking at any sort of criminal charge, we tend to focus a lot in the committees and all the things that are going on in the county, appropriately so, and a lot of the rehabilitative nature, which is important. But there's other aspects to the criminal justice system, too. There's accountability is one thing that we look at. We look at the punitive nature of what the penalties that we're looking to impose, and then the rehabilitative nature of the approach that we're going to take to the particular case and the charge. But all three of those things can exist in a single case. They're not exclusive well, this case will be punitive, or this case will be rehabilitative. They exist and live and breathe inside every single case that we have in some form in those individual cases. And one, just by way of example, I'll give you, look at an assault for domestic violence case. So one spouse has assaulted another spouse. In a domestic violence setting, one way to look at accountability and judging accountability might be the person taking responsibility for the crime, and that might look like pleading guilty, admitting that what they did at least was wrong, that they did something wrong. And most of the time when I talk to victims, over my experience, that's usually what they want, is an acknowledgement that what happened to them wasn't right. So that's a level of accountability. There's various ways this can go. I'm just giving an example. The second part of it might be a punitive, right? Okay, so what's the punitive? What's the penalty for behaving like that? Well, it might be a few days in jail. It's a mandatory arrest on a domestic violence, so maybe the perpetrator was booked into jail for a couple days, maybe longer if they've got history, but they're, minimally going to do, a day in jail if they were booked before they probably see the judge, about 12 hours or so at least. So that's your punitive nature. You've also got fines and other things like that. And then there's the rehabilitative portion of that, of addressing that case, which is domestic violence treatment, going to batterers treatment, going to get an evaluation, going through treatment, could also involve some alcohol treatment. And this is just an example, but the reason I give this example is, it shows you that not every case is just, well, this is a case to address, to rehabilitate the defendant, and this is the case where we only want to punish someone. Again, these concepts of accountability, punishment, rehabilitation, they exist in every single case in some form. And so, they might have different levels where in this case you want to focus on rehabilitation over punishment. You might want to focus on accountability over the other two. But just understand that those qualities exist in every single case in the way that we look at every case. Another good example, and kind of see is a DUI, sort of the disparity in the way these levels move is in a DUI case. A DUI or a similar offense, generally on your first offense, it's mandated that by statute, that you have to be in jail for about 24 to 48 hours on a first offense. You can get by with about, I think, 12 hours. They'll let you call that good. But basically, there is jail time that just has to be imposed if the person is found guilty. And it's a mandatory booking offense here in Whatcom County, so the person usually ends up in jail. Most people booked overnight spend about 12 hours because they also have to check their level and ensure that they're releasing them when they're not intoxicated any further. But I would say, in my experience, anecdotally, most people on a first-time offense DUI are in there at a 10 to 12-hour range. And the reason I bring that up is that experience, again, anecdotally, but large amount of anecdotes, over 11 years and a half years of experience of seeing people, particularly for younger people too, college-age people who get a DUI. That 12 hours in jail is a very eye-opening and I don't want to say rewarding, because it's certainly not rewarding, but it's an interesting experience that I don't know, countless number of times. When we later have sentencing and months down the road, they reference that time in jail as a very unique experience. And I will say the vast majority of our DUIs, defendants particularly of a younger age, we don't see back again. And certainly I know there's other factors, and it's not simply that they went to jail for a few hours. I'm not that naive. But it is something that certainly serves a purpose and certainly has an effect on their behavior, not only in dealing with that case, but going forward. And that doesn't mean, again, not naive to think that it solves all the problems in simply doing that, but again, it's those levels, right? That 12 hours is a real good, sufficient amount of time for that person to understand that, wow, what I just did really cost me, and I went to a place I don't want to go. The other part of that punitive might be, once they're found guilty, there's a lot of fines. If they had to hire an attorney, they're shelling out $5,000 for an attorney, so it's very expensive. The rehabilitative portion of that, of course, is that we're having them go and get an alcohol evaluation, go to treatment, go to victim impact panel, see how DUIs and other more heinous crimes like vehicular homicides or vehicular assaults, how those affect people. So again, that's a good example of how even a very short portion of time, of the punitive time being spent in jail, can have a very big effect on people's behavior going forward. But you have to combine that with the things like accountability. The person's going to plead guilty to a DUI or a lesser charge that'll count as a prior in their future, and you have the rehabilitation prong. So the best way I can always explain that is just to show you that those examples. But think of that DUI in the sense of a person like a 19-year-old student who gets a DUI and spends 12 hours in jail. We would all imagine, or even ourselves, right? We'd all probably imagine ourselves in that going, wow, that would certainly put an end to whatever I was doing if that happened. Now imagine yourself as someone who's already committed 20 other crimes and has been in jail a bunch. Those 12 hours are going to be meaningless to you. And the reason I say that is when we look at all the tools that we have, whether they're pretrial or post-conviction, that's the uniqueness and the individualness of each case, right? I can't just call it good for 12 hours for the individual who's on their 20th shoplifting. It's certainly not going to change their behavior, and they certainly don't care at that point. It's certainly not making the impact that we were sort of hoping it would. So now you're looking at those three things: accountability, punitive measures, and rehabilitation, and you're saying, okay, well, we need to be focusing more on the rehabilitative part because the punitive measure isn't working, and it isn't changing their behavior, and it certainly isn't having the desired effect. But, well, not to say but yet, but so you look at all the tools that you have, and you have to start focusing on these other portions, which are the rehabilitative prongs. And that's when we look at some of the things that we have. Maybe it's mental health court. So what you start asking yourself is, what's driving this behavior? Why is this person stealing? Or why is this person always committing assaults? You know, a couple people that come to mind are repeat offenders downtown. It's usually substance abuse, right? That's a very common one. Or it's mental health issues mixed with that, or it's a combination of the two. And so you start looking at what tools you have, whether that's probation services, whether that's mental health court, other supervision that we can have that doesn't focus on jail time and the punitive measures, but those have to be available, because that gets back to my previous presentation, which is I can incentivize those options, right? But I can't force those options. And a lot of people, particularly if the crime is more minor in nature, they're simply not going to take that long road of, 2 years of mental health court on a very minor case where I could just plead out and do, 5 days or 10 days, when that's easy to me because I've done that before. It's difficult, and it's a choice that they ultimately get to make. And we can try to incentivize those choices and try to get that and focus on the rehabilitative nature, but it is a hurdle at times. And so the idea is always looking at expanding our tools. What tools do we have? What things can we do to maybe make things easier? That maybe there is a program that we could utilize that isn't necessarily a full, 2-year mental health court, or waiting for them. Sometimes you're just waiting for them to commit the more serious offense. And it's always looking at what those tools could be, and usually trying to craft a unique resolution for that particular individual and for their crime. But it doesn't always succeed, and that's why you ultimately have to sometimes fall back to, and usually do, to the punitive measure, which is if a person fails or blows off probation, if they fail in mental health court, and we know that failure means a very long arc, right? It's not just an ultimate yank. It takes a long, long time to do that. At the end of the day, I mean, that's we talk about incentivizing these options, incentivizing these things. The ultimate thing that the court has at their control is the penalties, right? Which can be fines, which try not to dole out too much, but mostly jail time, which can be done again on friendship diversion services on an ankle bracelet. Now, that isn't to say that that's what we want to go to, or that we immediately go to that, but that has to be, you have to understand that in the justice system, all of this is driven, you're trying to modify behavior, but it has to be driven by incentives to some degree, right? Like, what threat do I have to say, you need to complete this evaluation, you need to go through this treatment, you need to sit through this treatment even if you don't think you need it, which a lot of them will, say that they don't. And if you don't, what's the consequence, right? And so again, that gets into that idea of accountability, and punitive measures mixed with the rehabilitation. And so that's something that you always have to keep in mind. I'm not here to advocate for punitive measures. I'm not here to say that I think they solve problems, but the rest of this doesn't work. The accountability prong doesn't work. The rehabilitation part doesn't work if you don't have that ability, unfortunately, because of consequences. And those consequences don't have to be immediately going to that, but you have to have that aspect. And so some examples of some programs we do, particularly pre-trial, since that's also the same as pre-conviction, by the way. A diversion, and I'll give you a good example, is an MIP. First time an MIP is a minor in possession of alcohol. So that's someone under 21 possessing or consuming alcohol. I think we'd all mostly probably agree that that person does not deserve to be in jail and doesn't need the punitive measures to be including jail time. So what we look at on first-time offenders, a good diversion that we've run for years since I've been here, is having the person complete 16 hours of community service, having them pay $300 in fines. We can convert some of that to extra community service if they have an inability to pay. And also completing Alcohol Drug Information School, or Western has their own program called ADCAS. I don't know what that stands for, but I'm assuming the AD in it stands for alcohol and drugs. But they complete those 3 things, they stay out of trouble, they come back in 90 days, and we actually dismiss the case, and it stays off the record. The benefit for them, right, the non-consequence, the thing they're getting, the reward they're getting at the end is they don't have it on their record anymore, right? And that's a big deal for them, and it should be. And for us, what we're getting is getting them to jump through some hoops, have some consequences, but at the end of that, not saddling them with a criminal conviction, which is important for them. Question?
Ryan, quickly, a minor in possession of alcohol, they don't get arrested then? You just give them these are their terms, and they don't go to...
No, they do get arrested as far as getting a citation from the officer, and then they have to show up to court, and at their arraignment, we give them that option. So it's not a pre-arrest where, well, I mean, it's kind of hard to... Arrest is a term that... It's a term of art. I mean, in that you're arrested if the officer, asks you for ID, you're essentially seized at that point. I mean, we start to get into some real shades of gray there. But from arrest and that you're issued a citation, you're not in jail.
You're not going
right,
to jail.
no, we're not in
I think
jail. That's what you mean by
okay.
arrest is ending up in jail.
Right.
No.
Okay.
No, but you are given a ticket either in person or by mail until, just like getting a speeding ticket,
Okay.
except it's a criminal
Yeah, and I
ticket
think
until
that's
they show
important,
up.
and Sergeant Ulmer had
Yeah.
discussed of how there are situations where, okay, I'm not going to take you to jail, but this
Right.
ticket is essentially me arresting
It is
you
yeah,
then
exactly.
saying you need to go to court, you need
Precisely.
to show up, and that's why if you don't appear, then
Precisely.
you're going to get in trouble, so.
That's exactly right. You're right.
Yeah.
And so then when they show up, then we offer them that. Another good example is a possession of marijuana, which since I've been here with marijuana's been legalized, but it's not for under the age of 21. But marijuana, while Washington State doesn't frown on it as much, the federal government certainly does, and they do, particularly when it comes to students applying for student aid. So students who get a marijuana conviction will actually lose their ability to get FAFSA funding, the free application for student aid, for a year, and if you get 2 convictions, it's the rest of your life. So those are serious consequences that are separate from anything that I could possibly issue or give out. So we try to work with people, obviously, in that situation. So a good example of a pretrial diversion there is having them go out and complete some community service hours, having them do an alcohol drug information class, and then that's the one where we usually reduce that to an infraction. It's a legal fiction. We normally just reduce it to something like noise disturbance or littering, whichever they prefer on their record. But it's an agreement between the parties, between us, the court's not involved. We agree, hey, we're going to give you a benefit at the end of this. You're not going to end up with a criminal conviction. You're not going to end up with a drug conviction on your record. But you're going to, again, jump through some hoops, do some community service, do the alcohol drug information class, then end up with an infraction where you're going to pay a minor fine. And I think those are a couple of good examples of using discretion, looking at the individual case, looking at that defendant's history and saying, this is a good way to, again, have some punitive effect here, but at the same time, have some minor rehabilitative effect. We don't need probation. We don't need to involve, probation officers in urinalysis and all that sort of things. We just, a good alcohol drug information class. And at the end of that, also giving them the benefit of not hitting them with a criminal conviction on their record, which I think most people would probably prefer not to have. I wasn't going to talk too much about the specifics of the programs that are on here, but if anybody has any questions, other than those 2 examples I just gave, I can give you countless examples, but I'm also happy to answer any questions you might have about those programs.
Do you have anything, Terry? Okay. Dan?
I'd like to thank the chair for recognizing me. I don't serve on this committee. I just wanted to see if my understanding around domestic violence counseling or therapeutic services, is there a dearth of those services in this community? Are there?
Yeah, well, I do serve on the board for DVSAS, so I should put that out there. I know that our organization is currently trying to start, I don't say doing a better job, but doing a better job of providing those services in our community. There are a couple of providers in town, and I think they do an okay job. I think there is some new standards coming out where that job could be done better. One of the things that I see consistently is that we have offenders failing to do domestic violence treatment fully because of the cost. These are private providers, and understandably, they're trying to stay in business, and they have to charge an upfront fee before you can take the class. Well, that can be cost prohibitive for many people, and one of the things that DVSAS is trying to do is to lower that barrier and to take away that cost barrier so that perpetrators would actually have access to the treatment, and it would no longer be a reason or an excuse that they can't afford it. So there is providers, but I would say there's not sufficient. It's not sufficient enough, and I think that it could be with the new guidelines coming out, new WACs are coming out to what governs how those treatment should go and how it works. There's just different models that exist. I'm not sure that we have a provider in town that's going to meet that standard. And so I think as a community, we really need to look, I'll get on my soapbox for a minute, as a community, if we want to solve the domestic violence issues that exist in every community, but certainly exist in our community, I think we have to take a very strong look at of how we're providing treatment and how we're providing access to treatment in our community.
Thank you.
Oh, yeah, Darlene.
I would just add that while we bring up domestic violence, one other factor that we really need to consider are domestic violence victims. While we want, there is a hard balance there between holding somebody accountable, wanting them to get help, but we also have victims, not only of domestic violence, but of other crimes that need to be made whole. And so that's part of the balance that you have in the criminal justice system when you're trying to, in a Ryan's place or a judicial officer's place, to weigh what is best in this situation. And that's why when I said domestic violence court, those victims actually come and let the court know maybe how this has impacted them, or their separation, how that is impacting them, when there's a protection order and they can't speak or meet, or there's children involved. So there's or let's say a theft downtown. I'm sure many of you heard, shoplifting and things, how that affects the shop owner, and they have some right to be made whole as well. So it's a balancing system.
Darlene, I had a question for you. In the past, we've had concerns about if we're sending people over to Yakima. And there's a period of time where sometimes people are in a mental health crisis, and it's probably the reason why they were arrested in the first place, not specifically for the crisis, but what they were doing in the crisis. In this screening process, have you all been looking at how we might be able to screen somebody to see if they're balanced, and if they're not, maybe things that we can do as a city to give them some opportunity to at least get out of the crisis before we then send them to Yakima to do either their time, especially if they're pretrial. Have we been trying to crack that nut a little bit more?
Unfortunately, we have no control over that. We must get them out after their arraignment. Okay. There have been a few exceptions, I will say, where the jail has really worked with us on some kind of issue. But Ryan's probably can attest to this as much as I can, that it's a very frustrating thing. Over 60% of the people that we're sending to Yakima are pretrial.
Yeah.
And what percentage of that is mentally ill, I don't know, but it is a percentage.
Okay.
And I don't know how we address that when we don't have anywhere to hold them here.
Yeah. And Mayor, there was at some point where the sheriff had, I think I read an email that we were going to start doing the pretrial thing across the county as well as for the city. Has that been happening, and has there been some help there?
It was communicated that they were going to start doing that, but there weren't any time frames, and there wasn't any, as far as I know, any direct action. But I'll let you guys.
So we're primarily
As
the
far as I
only
know,
ones doing pretrial removal?
I think Lummi, is
And
as
Lummi.
well.
Yeah.
Right.
Okay.
And I will say Lummy's come up with some great programs.
they have.
They have some great programs they've really been instituting
Yeah.
to try to address these issues.
Peter?
Yeah, I think I posed that question. There was a meeting of that Sheriff Elfo called judicial officers on one of the things that he was looking at. It was administrative booking, I believe was the topic, and I think he indicated that January 1 is what they're looking at for the county, if I'm not mistaken.
I think that's what I remember hearing. Yes.
Doing the pretrial, or having their own contract with Yakima so we can minimize the number of pretrial.
Do you see it behooving us in any way prior to that, if we did have a screening tool, to say somebody's in the midst of a crisis and then work out some agreement where at least those people get to have priority in the jail? Or is that we just have no control over
It
that?
pretty much is up to the administrator of the jail and the sheriff to make those determinations. So yes, we agree with you.
Okay.
I will say that I do think people are getting quite good treatment when we do get them to Yakima.
Yeah,
and
it's
really
just in
is
some
going,
cases it's been
I know, I
getting
get
them
that,
there
but,
in that process.
and we're finding a lot of people who are in crisis here to a crisis to the point they won't even get on the bus to go to Yakima, or warrant officers are transporting them. over there and taking them over there. So I mean, we are being asked to take them out of this jail, but they are getting an Eastern State Hospital, which is, we have Western State Hospital, mental hospital. They are there, and I mean, seeing our people, even by the time we get orders over, if we have different orders for competency, I mean, sometimes they're there before even fax the order over. They're over there to see people. So they really are, I will say it is, to at least assuage those fears a little bit. Once they get over there, it is really, they're doing a good job, as good as you can under those circumstances. So.
Okay. And then Darlene, for the screening tool, on number one, I just want to clarify, as I'll report out tonight, the disqualifications. These are, some people might say, well, if somebody's been convicted of something and they've served their term and they've paid their fines, why would that disqualify them from electronic home monitoring? And what you're saying is that these are related to RCWs, where you just can't put them on a bracelet if they've committed these, even if they paid all their dues and their time. Is that correct?
Correct.
Okay.
It's in the RCW, any violent offense, any sex offense, any drug offense, reckless burning 1 and 2, assault 3, assault of a child 3, unlawful imprisonment, harassment. Those are all specifically stated offenses in the revised Code of Washington.
And then within the risk assessment, number 2, has the defendant lived at his or her current residence less than 1 year? I can certainly see where that's a risk, because if somebody isn't housed and housed predictably, it may be very difficult to, 1, find them, 2, for them to keep track of when they're supposed to be showing up. But at the same time, we know that homelessness is increasing. We heard from the Department of Commerce that, for every, I think it was $100 up in rent, you can help me with this, it's 30 people predicted will go homeless. So we know that that's happening currently, and then when people are homeless, they can be in a position to commit more crimes just to live. Has there been some talking about that point in here, and where, in one way I can see where it would be a negative, but in another way, somebody might not have control over that, but still might be able to pose the ability to
Can I
be
answer
on monitoring?
just real briefly? Yeah, so remember, this is home detention. If you don't have a home, you can't go do your detention.
Yes.
So just the background of that, when you say homeless, they don't
Wow.
have a place to go.
However, I do want to point out that we have had several individuals that are homeless, that the Lighthouse Mission has worked with us.
Great.
And when we find out that someone is homeless, and that really is the sole reason they can't do a bracelet, I've called down there, and they have actually allowed people to be in their day center and check in with them at night. And we even currently have a homeless person on ankle monitoring who doesn't have a home, but it's mainly, we just wanted to know he didn't go to the wrong places.
Yeah,
And so he can travel where he needs to travel, but he can't go to the certain places that he's not supposed to be at.
So yeah,
He's-
if we had maybe a low barrier shelter that we've been trying to locate one, that could be helpful in the sense of allowing somebody to not have to go to jail simply because they can't say they're doing home monitoring. So
Right.
maybe we could talk to our county friends
Yeah, I
about
mean,
that.
the issue with that has been in the past is, what do you do during the day, right? The Lighthouse Mission, it's home detention, so you have to have a place to go. The Lighthouse Mission has worked with us in unique situations where they've basically screened the
Okay.
person, said, yeah, we can have this person help us out with some odd jobs, maybe around inside. Otherwise, where do you go during the middle of the day? So that's the
All
issue.
right. Are there any other questions from committee or other members? Pinky?
I did have one. I was curious. One of the things you said was the mental health court offers about 200 people per year in that program.
That, I
Probation.
need to correct that.
Okay.
The mental health program in probation handles about 200. Mental health court has a limit of 30, and that's between us and the county. Mental health court is different than mental health probation. The probation, we have probation officers who are specifically trained in dealing with mentally ill, and they have some extra resources. They've been trained in some other tools, and so they can do about 200, and Whatcom County subsidizes that from the mental health court, from their mental health budget. But mental health court, as I said, is only 30 right now. It's limited to, and that's with our people and the county people that can be involved, and it's a much higher bar to be able to get into mental health court, because there's certain illnesses that are not appropriate for court, for that system.
So in total, we have 30.
Mental health court.
what do you think our capacity or our needs actually are?
I'm going to let Ryan
You
address
know,
that.
it's not I've said this before, it doesn't solve all the problems. It's not like you can't throw a drug court and figure you solve everybody's drug problems. Frankly, we're not even at capacity now. You know, it's all a matter of scale, right? And it's a lot of factors that go into that. So while it might be a good fit, you know, you can draw that. What I like to do is, you know, I'm sure there's a name for this, but you draw the circle of everybody who has a mental health, you know, issue that we deal with in court. The circle inside of it that is people who qualify for mental health court is much smaller. And so it's not a one-size-fits-all approach to everyone with mental health illness. So what you're identifying to me is we have a lot of people with mental health issues that, you know, are in the system, and how do we deal with that and with them? And I agree with that. But mental health court is one tool out of many, probably. So all I can tell you is we're currently not even at capacity of our own abilities of what we can use in our court. And so I think we have to look at not only that as a tool, but are there other tools that other communities are using that we can steal their ideas and maybe use to address that issue, because it can't just be mental health court. But so, I mean, you know, again, it's like everything. There's really great ideas for all sorts of specialized courts, but we're in a weird situation where we're not like the size of the city of Everett, you know, where they're a smaller big city where they've got, it's a matter of scale, right? You can fund a huge project for X, Y, or Z because you've got enough participants. We have to look at, yeah, we have issues, but what level of those people actually fit into that program that we're funding or creating or whatnot. So it's a complex issue, right? But I don't think we're even at capacity yet on our mental health court.
Mayor Kelly?
Just to make a distinction between number 1 and number 3. Number 1 is in the RCW. Number 3, we have discretion of that. We do. So let me give you another interesting example. You have somebody who moved within a year, and they have a house. But if you just look at that, no discretion,
Yeah.
you have to say, no, that's, you know, check.
Well,
So-
remember that that's only half a point.
Half a point,
If you
and you have
look
to
at
add up.
this, you're only ineligible on the bottom if you have more than
4,
points.
Right.
And the ones that say 0.5, that's why our judge put them down to half a point, because we didn't feel that they should have as much weight as the others. So you could have 3.5 points. You can have 4 points, but once you go over 4 to 4.5, that's when you wouldn't be eligible on that section.
It just seems like that person shouldn't be penalized even half a point for having moved.
And the reason it's on there, it's in all 4 of the other tools.
Yeah.
The reason it's there is because what they see is that
Objective
people
risk
that move
factor.
around a lot do have,
Objective risk factor.
for some reason, that makes a difference.
Okay.
Well, you have to remember they're doing jail time at their home, and a lot of people will say that they have a place to stay, and a lot of times it's not actually their home they're staying at to do their time, which that has created problems in the past too. People go, they did 15 days at their friend's house, and now they have to do 15 days somewhere else. So that's why it factors in too.
Terry?
On the residency part, would it be a more accurate question to ask, since it's people who move around a lot, not that got evicted or that moved within the last year? So would it be more accurate to state the question and use the question, has moved more than X amount of time in the last X years? Because
That's a
that
good
would get to what you're saying as opposed to what this does. Because this basically just states, I moved this year and now I've got a 0.5. Would that
Yeah.
get to what you're saying,
It's
to the real measure?
I think it certainly would. I would just say I don't think there's anybody that's ever been denied because they're 4.5 because they didn't move. I mean, it's not an issue. We can
point,
talk
okay,
about it, but it's
you
not
can
it's
go
not been an
back.
issue, and it's always
Yeah.
discretionary up to
I
the
think-
judge.
But
So
if
it
you
hasn't
got-
been. No one's been disqualified in a year and a half simply
But
because
if you've
of
got
that issue.
an objective, then
Sure.
it would probably be best to state it to meet your objective, objections, as opposed to just more of an arbitrary.
I think you have a great point. It
Yeah.
just, and of course,
Right.
we're just giving our feedback. But I think any time when we know that, and you can see where, I'm assuming Judge Lev or maybe Commissioner Smiley, the ones that are 0.5 are things where, you know, we might have penalized a lot more back in the day. So where you haven't lived somewhere for a while. If you've previously been incarcerated, that's only 0.5. So we're saying that we understand that you've made some trouble in the past, but you've done your time in that. And then we also have the unemployment. You know, and of course we say, well, if you're a student, but we know that unemployment, all of these things lead to putting you in situations where you're more likely to commit a crime. So at least I'm hopeful in that I'm seeing a 0.5, but I think as we go on and you all are reevaluating your risk assessment, we can really look and make sure that what we're saying that we're concerned about are the values in our city, and we make it very clear that we're not going to penalize people for the circumstances that happen in life. So I think with that, if there's nothing further, no?
The one last point I'll make on this too
please.
is that in every situation, if somebody is determined by the warrant officers or probation not to be eligible, the court can overrule that and has.
I didn't
So
know
the
that.
court has said, even though you don't meet eligibility, I'm going to authorize you to be on
Oh,
the
great.
bracelet anyway. And I've seen that happen on a weekly basis.
Wonderful. Well, I'll just give us an update that on October 23rd in this committee, we will have Liz Swoval and the team from the Vera bring the report. And then on November 6th, we have criminal justice spending. So we'll be talking about that then. And with that,